This court is now in session. Please be seated.
Good afternoon and welcome to the Court of Appeals. We'll take just a few moments and talk about our procedure before we get started. I realize I've got experienced practitioners who are aware of how the process works, but I always feel better if we talk about it. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, which you may reserve up to 5 minutes of rebuttal time of your 15 minutes, proper way to do that is after you've come to the podium and introduced yourself to request that from the court, and then you'll be provided that rebuttal time. Appellee gets no rebuttal time. We have a lighting system on the podium. We believe the lighting system is very straightforward. 3 lights on it, green, yellow, and red. So long as the light's green, you've got plenty of time while you're making your argument. Once the light turns yellow, it means you're running out of time. And once the light turns red, it means you are out of time. We ask that you please respect those time constraints. One very important thing for everyone to keep in mind: these arguments are being live streamed. So as you're making your argument, whatever you say is going out all over the world on the internet. So be sure you're cognizant of that fact. These arguments will also be uploaded on the AOC website and on the YouTube website so that they can be viewed later on. Your panel this afternoon consists of Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
Kimberly Speranza versus Scott Michael Speranza.
Good afternoon. May it please the court. My name is Caroline Altschuler, and I represent the appellant in this matter, Ms. Kimberly Speranza, and I would like to reserve 3 minutes for rebuttal.
3 minutes. All right, you may proceed.
Thank you. I want to begin my presentation by walking through the procedural history in this case because it is quite different than what you typically see on appeal, where there has been a final hearing and there was testimony and evidence presented and a ruling from the trial court with findings of fact and conclusions of law. Instead, what we have here was a pretty contentious 2+ year divorce action where the most pivotal issue in dividing the marital estate was coming to a valuation of the parties' Class A common stock and a closely held business insurance assist. So much so that there were 3 experts involved in the case opining to the value, and the spread was about $40 million in terms of values across the board. So the stock was the most important aspect of the marital estate. In the midst of a multi-day trial in April of 2023, the trial attorneys ultimately abandoned the trial and began to attempt to broker a settlement deal in the hallway. And ultimately, there was a scrap piece of paper with terms on it that purport to be the assets awarded to a wife. That spelled out the exact amount to the penny of the cash that the wife was supposed to receive in the division, along with 500,000 shares of stock and insurance assessed with protection on shares. After this, everyone files back into the courtroom and the trial attorneys begin to make an announcement on the record. And if you read the transcript from April 19th of 2023, it becomes readily obvious that there was crucial language regarding this protection on shares and about this stock that was not announced on the record. For example, the wife's trial attorney stated, "Wife will receive 500,000 shares of insurance assist, period." There was no explanation that she would receive non-voting Class B shares or any kind of stock that was different than what the marital estate stock was. And then continue to state, we will work on this language with the experts. There is some specific language that we're going to use for anti-dilution of the shares, et cetera, et cetera. There was some back and forth exchange, but concluded with, we will work on this language. And nothing else is enunciated about this protection on shares, leaving it open-ended about what the agreement actually was about these protections. And so just to further highlight my point of not full material terms and details were outlined in this announcement was that the trial court continued to pause the attorneys throughout this announcement on at least 3 or 4 occasions and ask if there was going to be a written marital dissolution agreement with more full and complete terms. At no point did they even ever announce the assets that the husband would be awarded in the division. And so the conclusion of this announcement was the wife's trial attorney stating that the divorce will be on the grounds of irreconcilable differences. And everyone leaves, goes on their merry way. And as you can probably expect, why we're sitting here today on appeal is because the parties were unable to then reduce this oral announcement to a written agreement, which is required pursuant to the irreconcilable differences statute. And the 2 most crucial aspects that the parties had difficulties on when reducing this agreement or this announcement was that there was an error in the amount of cash that was available for distribution to wife, and there was heated back and forth exchange and revisions about what the language would be for this protection on shares on the 500,000 shares of stock and insurance assist. So the parties ultimately submitted competing motions to the trial court, and there was a hearing held on June 1st, 2023, where it was revealed that the husband had subsequently, post the April 19th announcement, adopted a new shareholders agreement that purports to award a wife with Class B non-voting stock, which is not the marital estate stock, which was Class A common share voting shares. And so what ends up happening at this hearing is that the trial court adopts husband's draft of a final decree and orders that this be entered as the decree of the court. And it's stuffed with terms and provisions that my client never agreed to, that were never announced on the record on April 19th, including an attorney fee provision, including a tort waiver provision that goes above and beyond, that waives the right to sue for any contractual issues that arise in the future.
Let me ask you, in reviewing the wife's proposed final decree, it appears in that proposal, you say the stock is non-voting. In addition, there's a provision in that proposed decree submitted by the wife for an attorney fee provision. How do you explain that if that's not what was agreed to? Why would the wife include that in the proposed final decree that was submitted to the trial court?
That is a really good question. I have racked my brain to understand why it would have said non-voting shares, because that was not what was on the scrap piece of paper that was being used that day of April 19th, and that was not what was announced on the record on April 19th before the court, that she would have non-voting Class B shares. It'd be less valuable than what the actual stock was in the marital estate. So I don't have a good answer for that. I don't know why that was included. It was incorrect to be included, to be honest with you. In terms of the attorney fee provision, that was in the wife's draft. I believe that I can only speculate that the parties were attempting to put together a marital dissolution agreement once they left court on April 19th, and they were unable to do so. And so it was just copy and paste. But this draft that was submitted by the wife is ultimately irrelevant because it was never accepted by anyone, nor was it ordered by the court.
Okay.
How complete does an announcement of a settlement have to be in this type situation?
It's a very good question, Your Honor. And it comes to the body of law about what is a binding consent judgment when you make an oral announcement to the court. And I've cited it in my brief that the parties must agree on all essential terms that are to be incorporated into the final writing. And the final writing must be understood to just be a mere memorial of the agreement that was announced in the court. And so one of the cases that I cited, Sevigny v. Sevigny, which is a recent case from the Court of Appeals, very similar set of facts that happen. Opposing counsel, I believe, was actually involved in this case too, where during a trial, the parties go into the hallway, try to broker a deal, come to a quasi-agreement, come in and announce some of the terms, but not everything. They just say, we have a plan for the 529. Then same thing happens where they're not able to reduce it to a full writing, and the court dismissed the petition. And this, Your Honors, reversed that and vacated the trial court's decision and said there was not all the details were described on the record, especially with this 529 plan. So in our case, the biggest asset was this stock. And my client took on the 500,000 shares because she was bargaining for the protection on shares. And she did not get the language that she thought was being brokered that day. So there's ultimately not mutual assent to those terms. So it does have to be almost bulletproof what you announce to the court as to what the agreement is.
But you had an evidentiary hearing on this matter subsequently, didn't you?
I'm sorry?
You had an evidentiary hearing on what the agreement consisted of, did you not?
No, there was not. They just had on June 1st a hearing. Really, it was just oral arguments between the attorneys, but the husband did testify that he had subsequently adopted a new shareholders agreement that was different than what was in existence at the time of April 19th.
So that was the only evidence that was presented?
On June 1st, and I believe Mr. Price, who was the husband's expert, testified a couple sentences that he had worked on anti-dilutions, stock language. But yes, that was the hearing, and they submitted their final decrees, or their drafts on June 1st, but that was the extent of it. No one else testified to those issues. But in any event...
What is the evidence in the record on mutual mistake?
On mutual mistake, with the cash, it is the technical record. Leading up to the trial, there was $140,000 that was dispersed to wife from the marital estate.
Is there testimony about this?
There's no testimony about this.
Are there affidavits?
Technical record. No, Your Honor. There's no affidavits.
Is there any testimony about any mutual mistake at all?
There's the husband's pleadings, who admits that there was an error in the cash that was to be dispersed. In his motion for the June 1st hearing, he puts in there, it is now known that it was an error, that the cash available in the clerk's office was not what was stated on the record.
Now, at the time of that announcement to the trial court of the agreement, as I understand it, what was initially announced is that the wife would receive all of the cash on deposit with the clerk's office. Is that right?
Yes.
And that announcement was made by the wife's attorney.
The wife's trial attorney.
And then the attorney goes on to say the amounts that they apparently thought it was.
Yes.
But the fact of the matter, the wife was present at the time of the closing on these two parcels of property and knew what the net proceeds were, as I understand it. Is that right?
Yes, sir.
And she was also aware that checks had been written to her attorney, and that money was going to come out of those proceeds that were being held by the clerk but at the time of the announcement, those checks had not been negotiated. Is that right?
That is correct, sir.
And so that total of $3.4 million or whatever it was actually still in that account. And the 140 that came out later, did your client not get the benefit of that 140 pursuant to the trial court's order that each party would be responsible for his or her own attorney fees?
Yes, Your Honor. Well, the 140,000 was already ordered as a distribution from marital funds. So ultimately, what happened is my client paid half of his attorney's fees. His attorney got a $100,000 trial retainer that had been pulled out from the net proceeds, but yet the check that she was supposed to receive, the $130,000 is what it was for attorney's fees, and $10,000 for a joint neutral valuator retainer, that hadn't cleared yet. So the intention, and it's in the technical record, was those fees were all coming from marital funds first before any division was supposed to take place. I understand I'm out of time. Thank you.
Good afternoon. May it please the court. My name is Laura Bloom of the Nashville Bar on behalf of the Appellee, Scott Speranza. We would submit to the court that this is a classic case of buyer's remorse. The wife in this case has decided after the fact that she did not like the terms of the settlement agreement that she swore in open court that she understood and agreed to, as announced by her prior counsel in this case, and has been attempting to work her way out of that agreement ever since, with no real basis in fact or law to support her position, while simultaneously enjoying the benefit of the agreement that was announced in open court. She withdrew $3.4 million from the clerk's registry on June 13th, 2023, the day after the final decree was signed. The final decree that was submitted was signed by her counsel, as well as Mr. Speranza's counsel. And Ms. Speranza also withdrew those funds after she filed her counter motion to enter her version of the final decree, in which she claimed that there was an error, that she should have received a different amount of funds from the clerk's office. The parties' agreement in this case was entered as a consent judgment. The law is clear that consent judgments are some of the strongest and most enforceable agreements that a court can make. The agreement of the parties was announced in open court in detail on the record and was transcribed in a certified transcript. The trial court granted the parties divorce under the Tennessee statute, and I believe that's an exact quote from the transcript of April the 19th of 2023, under the Tennessee statute, and found that the agreement was, quote, an excellent settlement. The fact that the final decree states that the parties were divorced on the grounds of irreconcilable differences, in our opinion, is immaterial. It is important to remember that many of the very terms that wife now objects to being included in the final decree were included in her proposed final decree that she presented to the trial court and asked the trial court to enter. She was in court on June the 1st of 2023 when that final decree was made an exhibit, and she was also in court on June the 1st, 2023, when husband presented her with the amended shareholder agreement for insurance assist, which provided that she would have the same terms in that shareholder agreement as were contained in the December 30, 2020 shareholder agreement, which her counsel on the record stated that Ms. Speranza relied upon in negotiating the agreement on April the 19th of 2023. And that's important to remember because those two documents were identical, and Ms. Speranza comes to the court now asking for relief and asking for different terms under the shareholder agreement when she's claimed that the terms that are contained in that agreement are what she's relied upon in negotiating this agreement. Similarly, wife complains of provisions of the agreement claiming that it does not contain all the material terms regarding the regarding the shares of Insurance Assist. If you review the transcript of the announcement against the language of the final decree, it tracks pretty closely. And wife's expert, Vic Alexander, was present in court at the date of the announcement and went on the record as part of the announcement. There was some discussion between counsel, the court, and Mr. Alexander. And those discussions, I think the court would find, are included in the final decree of divorce.
Let me ask you, in the announcement that was made at the time that the case was settled, was there any announcement about what shareholder agreement would be in effect?
No, Your Honor. There was no announcement about what shareholder agreement would be in effect.
So why would there be language in the proposed decree that would make the amended shareholder agreement to be effective as against the wife's shares?
The final decree ultimately required her to sign the shareholder agreement. And I'm sorry, I don't recall off the top of my head whether it specifies that she has to sign an amended shareholder agreement or just a shareholder agreement. But it really should be immaterial because the shareholder agreement that she was presented with is identical, but for a non-disparagement clause that was added to the shareholder agreement prior to the entry of the announcement of the settlement, and that had been incorporated into all of the other shareholders' shareholder agreements. So effectively, wife was being asked to sign a shareholder agreement that was identical to all other shareholder agreements, including Mr. Speranza and all other minority shareholders.
If under the terms of the dissolution of the marriage, she was to receive 500,000 shares, why would she necessarily be required to even sign a shareholder agreement?
It's my understanding that all shareholders in this company are required to sign the shareholder agreement. And it was part of the final decree ultimately that she was to sign it.
But again, not announced at the time of the settlement.
Not announced. And I'm not aware of, at this juncture, whether or not Ms. Speranza included any language that she would be signing a shareholder agreement in her proposed final decree. I've not reviewed it for that specific language.
So you believe that to own shares in this company, it's a requirement to sign a shareholder agreement?
That's my understanding.
Where would we find that?
I would assume in the shareholder agreement.
Where would we find it? Is it in the record?
The shareholder agreement is in the record.
No, the requirement.
I'm not aware of that. It may be in the shareholder agreement, which is in the record, but I am not aware of where that would be within the shareholder agreement. I've not reviewed it for that provision. With regard to the
Well, let me ask you another question then, as I asked opposing counsel. Apparently, this announcement's been made. Then subsequent to that, there's some disagreement about what the agreement actually was, and then you have a hearing, whether I assume it was the motion to alter or amend or a motion to enter the decree. What evidence was presented at that time to either support the entry of the decree or that opposed the entry of the proposed decree?
Yes, Your Honor. So that would have been the June 1st hearing, June 1st of 2023, on the cross motions to enter final decrees. The evidence presented was the proposed final decrees of both parties, as well as the amended shareholder agreement was also an exhibit to that hearing. Mr. Speranza testified briefly, and I mentioned in my brief that he had testified incorrectly upon review of the shareholder agreement. It's clear that there are no changes to the shareholder agreement or to the classification of stock therein. Mr. Speranza, I believe, testified that he thought there was a new class of stock created, but that's just simply incorrect. But other than that, I don't recall what evidence was presented at that June 1st hearing. I do recall there was a spreadsheet of funds in the clerk's office that was presented as an exhibit that Ms. Speranza presented to the court that accounted for all of the various funds coming in and going out of the clerk's registry. And perhaps a copy of the asset and liability statement from the final hearing that was presented before we terminated that hearing.
Would that have been all the evidence that was presented subsequent to the announcement of the court?
To the best of my recollection, but I can't say with any certainty at this point.
Thank you.
If we found that all of the provisions in the final decree were not actually made as an announcement to the court and accepted by the court, what would be the remedy here? Would we vacate the entire thing, counsel?
Well, Your Honor, I believe that I cited a case in my brief about the importance of the completeness of the announcement and how to determine the intent of the parties in that regard. And I believe that there was case law presented that states that if there are certain terms that are necessary to the completion of the settlement agreement that aren't necessarily pled for, that can be incorporated into the consent judgment. But as far as a remedy, if the court does find that all the essential terms were not contained in the agreement, I believe that the final decree contains a severability clause. That severability clause was included in both proposed final decrees of the husband and the wife. So it would be our position if the court were to find that there was a certain provision of the final decree that was not enforceable or invalid for some reason, that the remaining provisions of the final decree would still be enforceable. As far as the funds in the clerk's office, there's no dispute that the funds that Ms. Speranza received from the clerk's office, the amount was not the same, if you do the math, as the amount that would have been listed under the final decree or under the announcement. But that is accounted for with the $140,000 that she was that was awarded to her as attorney's fees to come from the net proceeds of the sales. And I think that's the important language of the orders regarding the proceeds from the sales of these properties being deposited into the clerk's office and then ultimately the attorney's fees being paid, was that the court was careful to include the word net. So the net proceeds came in, and then I believe the order states that Mr. Hollins was to receive $110,000 from the net proceeds that have been received from the sale of one of the properties, I believe it was the farmland, into the clerk's office. Because of that, it should have been clear to wife, and the fact that Mr. Hollins announced on the record on April the 19th that he had just picked up the check that day, that those funds were included in the amount that was listed, but she was already receiving the benefit of those funds. To assume otherwise would basically be to say that she was just asking for additional funds, which was not part of the agreement. Ms. Speranza also raises the issue of grounds that are stated in the final decree. The final decree states that the parties are declared divorced, I believe, under the grounds of irreconcilable differences. It's our position that this court should find that for all intents and purposes, the parties were declared divorced under TCA 364129, which allows for the trial court to declare parties divorced based on stipulation or proof of any ground, and granted divorce to either or both parties on fault or the grounds of irreconcilable differences. It's noteworthy that the wife's attorney went on record at the announcement on April the 19th, and after consulting with her client, stated that, I believe, we're going to, she said something to the effect of, we're going to give the wife the divorce on the grounds of irreconcilable differences, and we will incorporate that into the order by stipulation. And that's in the April 19th announcement. And so it's our position that the wife and the husband had agreed and did agree on the record that they would enter a final decree and not a marital dissolution agreement. That wife would be awarded the divorce on the grounds of the parties would be declared divorced on the grounds of irreconcilable differences. But in any event, this is simply, if it is an error, it would amount to a flaw in procedure or a mere procedural flaw, which would not render the order declaring the parties divorced void in any way. And it's our position that the court can essentially interpret that as just a clerical error or an error that was overlooked and that was not brought to the attention of any court by the wife until after the hearing on her motion to alter or amend in August of 2023. Thank you.
Just a couple of things. On the extension of the protective order, is that still an issue, or has that time expired?
It has expired. Our assumption is that it's moot. The wife has not raised it as an issue, I don't believe, in this case, but she has raised it as an issue. It was mentioned in a footnote in our brief, but it has expired, so we assume that it's been rendered moot.
And then on the attorney fee provision, you agree that there was no announcement about the attorney fee provision?
I would agree with that. It was included in both proposed final decrees.
Okay.
Thank you.
Thank you.
Thank you. And Judge Stafford, I did want to swing back to your question that you had earlier about additional evidence. And at the Rule 59 hearing, the scrap piece of paper that had been used in the hallway was introduced and presented as evidence. And on that piece of paper, it is very important to note that, again, it says 500,000 shares in Insurance Assist. It does not say Class B non-voting stock, and it says protection on shares. And there is no attorney fee provision on this piece of paper, nor was that ever announced, as you stated, Judge Armstrong. And so really what we have to come back to in this case is the basic fundamental elements of contract law. You know, the trial court, the best illustration of the issues in this case is the trial court stating or ordering that my client was responsible for the husband's attorney's fees based on contractual provision of this attorney fee provision under Everbach. But my client never agreed to this provision. It was never announced on the record by any means. And so that highlights the issues that we have in this case, that there was no marital dissolution agreement that was submitted to the court. And the trial court was, in reviewing the transcripts, anticipating for a written NDA to be provided. On the date of the April 19th at the announcement, stopped the attorneys multiple times and asked, will this be described in further detail in an MDA? That was asked about 3 or 4 times, especially, again, the husband's assets were never even announced on the record on April 19th. And so, and going back to the June 1st hearing as well on the competing motions, was the court recognized there are a ton of spin-off scenarios that can happen here because there is no MDA. There's no marital dissolution agreement. And so ultimately, we have this final decree that's entered against my client's objections with all these terms that were never announced on the record, and material terms specifically about these protections on shares that were never announced on the record. And so it is not a valid binding consent judgment. It's not a contract. It's not a valid final decree, because you cannot have irreconcilable differences divorce if you don't have a written agreement.
So what are you asking us to do?
To vacate?
To vacate?
Yes.
And the $3.4 million would be clawed back into the clerk's office?
Everything can be accounted for, yes, sir.
Okay.
Thank you.
Thank you.
Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may be excused.